Hello and welcome to Narayana IS. I'm Pratik, your faculty for daily news analysis. Students, in today's DNA, we shall be discussing four topics from the Hindu newspaper. But before we begin discussing all the topics, let us focus on a motivational quote that may boost your confidence in the preparation. So, what is today's motivation quote? An investment in knowledge pays the best interest. This highlights the importance of seeking and acquiring knowledge. Because when you acquire knowledge, no one can fool you. You are in that position to take decisions independently. No one can influence your decisions because as you seek acquired knowledge, you can take the decisions to the best interest of your life. So be it personal life or professional life, seeking knowledge will help you immensely. And then of course in the examination, the more knowledge you acquire, the more dimensions. By more knowledge, we focus on the more dimensions. So the more dimensions you write in the means answers, or let's say in the essay paper, the more marks you will fetch. And this will help you to clear the examination. So always understand the importance of seeking and acquiring knowledge, right? So all the students who want to prepare for the UPSC examination and also clear the examination, right? For all those students who want to prepare for the examination and also clear the examination, Narayana IS has introduced 1 year and 2 year prelims cum mains integrated program. For the students who have covered the basics, 1 year would suffice. For the students who may take time or who are in graduation may opt for the 2 year prelims cum mains integrated program. The focus will be on holistically ensuring that your pre and means related concepts are clear, right? So these are the details of the program, right? So if you want to enroll in our program, I request you to scan the QR code visible on the screen and also contact on the given numbers. Our team will get back to you. So here you can understand the features of our 1 year and 2 years prelim cum means integrated course. So in this course, we'll provide you each and everything. You don't have to refer to anything outside what we provide. And we assure you that of all the material that will provide you, the resources will be more than sufficient for you to not only clear the examination but also top the examination, right? So on this note, let us start today's DNA. So these are the four topics that we have chosen from the Hindu newspaper. The first article talks about UAPA, that is Unlawful Activities Prevention Act. Now, how the implementation of UAPA has become a big problem, or how the people who are charged or accused under the UAPA provisions have to spend months and years in jails without being declared guilty. So this is the first topic of the day. The second topic talks about the importance of right to information, RTI Act 2005, and how the central government is trying to dilute the provisions of the RTI Act. The third article is taken from Hindu page number 9. Now this article talks about China's long-term plan in Africa. Now this long-term plan includes economic influence, military influence, ideological influence. In short, China tries to directly or indirectly control the entire Africa. And the fourth article talks about a law which the central government had enacted in the year 2023, which goes against the judgment of the Supreme Court relating to the appointment of Chief Election Commissioner and the election commissioners, and how the act will impact the independence, neutrality and integrity of the Election Commission of India, a constitutional body. So these are the four topics of the day. Let us start with the first topic. The title of the first topic is how the UAPA, a draconian law, a harsh law, is wrecking lives, that is affecting lives. And here we'll understand what is UAPA and the different provisions and the major issues of UAPA. And you may relate this particular article under GS paper 2, that is important aspects of governance, transparency and accountability. So a question was asked in the year 2019, a PYQ. The question was, Indian government has recently strengthened the anti-terrorism laws by amending the UAPA 1967 and the National Investigation Act. Analyze the changes in the context of prevailing security environment while discussing scope and reasons for opposing the UAPA by human rights organizations. So, in order to address this particular question, you need to have a holistic understanding of UAPA Act and most importantly, the challenges under UAPA. So, let us understand the context. What is UAPA? UAPA is unlawful activities, Prevention Act 1967. This is the full form of the UAPA. What is the purpose of the law? The purpose of the law is to counter to counter to, to counter terrorism and unlawful activities. The purpose is to counter terrorism and unlawful activities. Now, unlawful activities, which means any activity or activities that may or might affect the territorial integrity and sovereignty. Any activity or activities that may harm the territorial integrity and sovereignty of our country. For example, let's say if there's a protest, the protest intends to break Kashmir away from India. Or let's say some of the northeastern groups are protesting to make few regions in the northeast as independent country. Now this is harming or impacting the territorial integrity and sovereignty of India. So any activity that harms or impacts the independence, India's control over her territory, will be brought under UAPA or to counter terrorism. This is UAPA and the purpose of UAPA. I hope you understood what is UAPA and why the UAPA law is used. Why? To counter terrorism and unlawful activities. And what do you mean by unlawful activities? I have explained. The provisions are very strict, which means when a UAPA case is filed against a person, against an accused person, granting bail becomes very difficult, which means most probably a person who is accused under UAPA won't get bail. This is what we understand by the term stringent provisions, which means prolonged incarceration is jail, which means once a person or once a charge is charged against an accused person under UAPA, a person has to spend months and years in the jail. Why? Because granting bail is simply not possible when it comes to UAPA cases. Why? Because the police, when it comes to UAPA, when it comes to UAPA, they rely on the police reports, and the police reports are often fabricated, which means without allowing the defense to present counter arguments, bail is simply rejected, which means it hampers the fairness in proceedings. It impacts the due process of law. The way UAPA is implemented, it highlights the flaws. It highlights the flaws in India's criminal justice system, which means the provisions of UAPA can be misused and have been misused. The implementation, it highlights the flaws in India's criminal justice system. I hope you understood what is UAPA, the purpose of UAPA, why granting bail is very difficult, because the courts have to rely on the police reports, right? And this implementation has brought to light the inherent flaws in India's criminal justice system, which means the provisions are prone to misuse. Now, UAPA in the year 1966 was introduced as an ordinance. Now, ordinance is nothing but a law. Ordinance, it carries the same meaning as law. It's a temporary law, right? But this ordinance was later on converted into an act in the year 1967. What is the purpose? I have explained you. That is to counter terrorism and unlawful activities. Now, when it comes to UAPA cases, the National Investigation Agency NIA is empowered to investigate and prosecute cases under UAPA, which means the NIA, whenever a case is filed against a person under UAPA, NIA is the competent authority to prosecute, to investigate a case filed under UAPA. The NIA has also got the power to seizure or attach the properties of the accused. The NI is the competent authority when it comes to UAPA. Now, the UAPA Act of 1967 has been amended several times. For example, it was amended in the year 2008, 2012, 2019. With every amendment, the scope of the UAPA was expanded, which means many aspects, many offences were brought under the ambit of UAPA. For example, terror financing, cyber terrorism, or in the year 2019, even individuals can be designated as terrorists, which means with every amendment, the scope of UAPA was expanded, which means UAPA was strengthened. terror financing individuals to be designated as terrorists. The scope was expanded with every amendment. Right? Now, time frame. Time frame, which means the investigating agencies like the NI. See, whenever, let's say, for example, the police has filed a case against me, right? Now, the police has to produce a charge sheet. Now, the charge sheet would entail detailed evidence against me. What crime I have committed, the evidence for the crime I have committed, everything will be mentioned in the charge sheet. Right? So, here the investigating agency, right, have to prepare the charge sheet within 180 days, and this duration can also be expanded or prolonged with the approval of the court. 180 days, it can also be extended with the court's approval. So time frame is 180 days. Now this act applies to both Indians as well as foreign nationals, which means it is also applicable to offence committed outside India. Now the penalties are as harsh as death penalty, death penalty or life imprisonment. These are some of the major provisions of UAPA. Now, let us try to understand the Supreme Court interpretation with respect to UAPA. In the year 2011, in the Arup Bhuyan versus State of Assam, the Supreme Court held that just by being a member of member of banned organization does not constitute an offense unless accompanied by an evidence involving violence. Let's say an organization is banned and you are a member of that organization. Now, a person cannot be prosecuted just because he is a member of the banned organization unless he is involved in a violence or violent act. But this observation was overturned in the year 2023, where the Supreme Court held that even being a member of the banned organization is an offense. This is how the Supreme Court interpreted in the year 2011 and 2023. Now, in the year 2004, the Supreme Court held that to combat terrorism, you cannot violate human rights. This highlights the importance of human rights. You are free, the state is free to fight against terrorism, but you cannot violate human rights because this undermines the due process of law. This undermines the due process of law. Now, in the Mazdoor Kisan Sangathan versus Union of India 2018, Supreme Court held that peaceful protests against the government is legitimate. So, if a group of people are peacefully protesting against the government, this is legitimate. It is a constitutional right of an individual or group of people. And then finally, in the 2019 or rather 17 case, Hussain versus Union of India 2017 case, the Supreme Court held that bail, the general principle that the courts should follow is that the bail is the norm and jail should be an exception. Jail should be an exception. So this was the direction given by the Supreme Court to all the courts that even in the UAPA cases, bail should be the norm and jail should be an exception. So these are some of the Supreme Court interpretations. Now, if I talk about the challenges in UAPA, right, the first and foremost is low conviction rate, which means a person is accused under UAPA, but this accusation, or rather, a person is not proved guilty. A person is only blamed, but this blame is not proven, or this blame, the Supreme Court does not uphold the blame, which means somewhere here you need to understand that low conviction, which means let's say the conviction rate is 18 percentage. Let's say if UAPA case is filed against 100 people, only 18 people out of 100 people are convicted, which means their charge is held true. They are proven guilty by the law. Rest 82 people have to spend months and years in jail without being proven guilty. Their guilt is yet to be proven. Their guilt is yet to be proven. And before their guilt is proven, they have to spend months and years in jail. Low conviction rate. Right? Now, the next one is subjective interpretation. What do you mean by unlawful activities? Unlawful. Now, this term is very vague. This term is subject to subjective interpretation, which means the government can interpret an activity as per its own, let's say, convenience or understanding. Because the term is so vague, let's say, for example, an individual or group of people are protesting against the policies of the government. The government can also misinterpret this activity under unlawful activities and slap the person with a case under UAPA. So, another challenge is that the term is very vague and it is subject to misuse. The third one, limited judicial review. Now, the 2019 amendment of the UAPA stated that even an individual can be designated as terrorist, but without judicial review, which means the individual who has been slapped with a UAPA case cannot approach the judiciary. The government files UAPA case against a person, this person cannot appeal against the decision of the government. This undermines the rule of law. This undermines the fairness in proceedings. The third challenge. Fourth, detention rules. Now, when it comes to UAPA, the government can detain a person up to 6 months. See, in normal cases, the government can detain a person. Detain is, let's say, keeping a person under observation. The person has not committed a crime. To stop a person from committing a crime, the government has the power to detain a person. In normal cases, the government can detain a person up to 3 months. But under UAPA, the government can detain a person up to 6 months. Now this is arbitrary. This contradicts the fundamental rights of a person. Right? Now, the next one is violation of fundamental right when it comes to Article 19. What is Article 19? Freedom of speech and expression. Freedom to assemble. Now, the UAPA violates the fundamental rights of citizens, the fundamental rights being sacrosanct in nature. Right? Then extended delays in bail hearings. Once, as I told you, once a case of UAPA is slapped against a person, usually the person does not get bail. The extended delays, which means the hearings for the grant of hearings for the grant of bail is often extended. It's like tarik pe tarik, tarik pe tarik. These are few challenges under UAPA. Right now, why the bail hearings are extended or why the bail is not given? Because the courts rely on the police report. The police reports can be fabricated. At the same time, the accused is not given a defense lawyer, or rather, the counter arguments of the defense lawyer is not heard. So, this is a genuine problem. So, what should be the solution? The solution is UAPA. It's not that the UAPA is not important. UAPA should be used as the last option. Let's say, for example, if people are criticizing the government or individuals are protesting against the policies of the government should not use UAPA against the students or let's say organizations who are criticizing the government. We have seen that the government has used UAPA against the academicians, the journalists, the human rights defenders, the civil society actors. Right. So here the author intends to highlight that UAPA should be used as a last option. The government is free to use provisions under IPC, but UAPA should be used as the last option because once UAPA is slapped against a person, his entire life will be ruined. Why? Because most often, the experts have noted or observed that this law has been misused. Second, need for amendments. Now, it is very important to redefine 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 the term unlawful activities. As I told you, unlawful activities is prone to misuse. So here it is very important for the government to redefine the term unlawful activities, which means specific criteria and circumstances should be established or defined under which a person or a case of UAPA can be slapped against a person. Non-biased review mechanism. Now, an independent and impartial review mechanism should be established by the government so as to verify the claims of the government. Let's say the government has filed a case against me, UAP. Now there has to be an independent review mechanism, a body that should revisit the charges the government has slapped against me. The government can be biased, but having this independent and impartial body will ensure that the arbitrary decisions taken by the government can be checked and countered. Next, presumption of innocence. Now, the general principle that the government or the courts should follow is that innocent until proven guilty, which means it is often in the under the general principle that the courts follow is that a person is considered to be innocent until proven guilty. It is a job of the prosecutor, that is the government, to verify, right, or prove that a person has committed a crime. So the responsibility, the burden of proof should lie on the shoulders of the government or the prosecution, which means until the guilt of a person is proved, the crime of a person is proved, the person should be considered innocent. And then there should be clearer grounds for denial of bail. As of now, the bail is denied arbitrarily. The author intends to highlight that there should be clear grounds, criteria, circumstances established under which only bail can be rejected. So these are some of the proposed reforms to ensure that the efficiency and implementation of UAPA is effective and the law is actually making an impact on the society in terms of impact in the sense positive impact. I hope you understood the first article and all the provisions. Let us start with the second article. The title of the second topic is Cripple and Scuttle. Now here we'll understand the importance of Right to Information Act. Again, you can mark this topic under GS paper 2, important aspects of governance, transparency and accountability. Now there's a question on RTI Act in the year 2019. There is a view that the Official Secrets Act is an obstacle to implementation of RTI Act. Do you agree the view? Discuss. So, what is the context? Now, the context is that right to information. RTI refers to right to information. Right to information, which means every citizen has a right to seek information from the government. This ensures, this secures or ensures transparency and accountability. As the citizens pay money in the form of taxes to the government, the citizens have the right to understand how the government is operating. Which means we have the right to know how much money the government is spending for education, for health, for public services, for military, for research and development. So we have the right. In order for the people to have the right to seek information, Right to Information Act was enacted in the year 2005. Now, every citizen has a right to approach the public authority to seek information. I hope you understood what is RTI and the objective of RTI Act, that is to seek information from the government. But challenges to effectiveness, the law or the implementation of the law is very poor. The government delays providing the information. The government comes up with some or the other reasons. The government amends the act. The government delays providing the information. Thereby, the government is diluting the essence of the RTI Act. Now, if I talk about the vacancies, so information commissions. Now, information commission is a commission where information is accessed by the common people. There are vacancies at the central level as well as at the state level. For example, if I talk about at the central level, there are 23,000 vacancies. So if there are so many vacancies, which means a person, let's say a person has requested for an information. Now there are no officials to work in the commission to give or provide the information. Now this will discourage citizens from seeking information. This impacts the transparency and accountability as well. Right? Now, enactment and implementation, I told you that it was enacted in the year 2005. What is the purpose? Right? To seek information from the government. Now, coordinating agency. The Department of Personnel and Training. The Department of Personnel and Training under the Ministry of Personnel, Public Grievances and Pensions. It oversees the implementation of RTI. This is a ministry. Under the ministry, we have this department, and this department is responsible to ensure the implementation of RTI. Now, RTI was first introduced in the year 2002 as Freedom of Information Act. But then this act was replaced by RTI Act in the year 2005. Right? Now, if I talk about the judicial recognition, now see, the Supreme Court in 1975 held that the right, which right? Right to information is implicit in the right of freedom of speech and expression under Article 19 of the Indian Constitution. Before the right was framed in the year 2005, in the 1975, the Supreme Court held that right to information is inherent in Article 19 of the Indian Constitution. In the year 1982, the Supreme Court asserted right of the people to know about every public act and the details of every public transaction undertaken by public functionaries. The Supreme Court elevated the status of right to information to a human right and linked to right to life. See how the importance of right to information has evolved. Here, the Supreme Court is elevating the status of right to information as human right. Here, in 82, the Supreme Court held that right to information is inherent under Article 19, that is freedom of speech and expression. But now, here in this case, 2004 case, the Supreme Court held that no, RTI, the right to information is linked to right to life under Article 21 of the Indian Constitution. This is how the right to information or the importance has evolved. Now, if I talk about the institutional framework, right? See, the central and the state information, the Central and the State Information Commission, as I told you, they oversee the implementation of the information. And they also address the appeals regarding the non-disclosure. Let's say, for example, now who are these PIO? Every government body has an officer, public information officers, the central, that is the central as well as the state. In every government office, there is this officer called PI. Now, this person, this officer is responsible for providing information to the citizens. In case you're not happy with the information provided by PIO, you can approach the Central and the State Information Commission. Who provides the information? Not the commission, the PIO. They provide the information. Right? Now, rights provided, right to information, which means every citizen. Here, the keyword is every citizen has a right to file an application seeking information from the government or public authorities. And obligation of public authorities, the public authorities under the RTI Act 2005, they are bound by the provisions of RTI Act, which means they have to ensure that the information requested by a citizen or group of citizens should be provided. The scope of coverage, now this applies to the government bodies established by the constitution, or let's say the laws framed by the parliament. Let's say UPSC is a constitutional body. National Human Rights Commission is a statutory body. That is, this body was framed because of a law passed in the parliament. Now, any NGO that is substantially financed by the central or state government also comes under the ambit of RTI. Right? These are some of the provisions of RTI. Now, providing the information to the citizens does not mean that the government provides each and every information. No. Section 8 of the RTI Act exempts RTI Act of 2005. It exempts certain classified information from providing to the citizens. For example, information pertaining to the national security or privacy of an individual cannot be disclosed. For example, when it comes to intelligence and security organizations such as IB, RAW, NIA, the certain, we cannot ask information pertaining to the national security from the government. Section 8 of RTI Act exempts providing information pertaining to national security or privacy. Jurisdictions, the lower courts, that is the courts under high courts, are barred from receiving any application pertaining to RTI, which means when it comes to RTI, only the Supreme Court and High Court can entertain the petitions. Simple. Now, which are the other key provisions? Penalties. So, the officers, the PIOs, the public information officers, can be penalized if they fail to provide information or they provide wrong information to the citizen. Time frame. Now, when an application is filed by a citizen, the information should be provided within 30 days. And if the issue pertains to, let's say, life and liberty of a person, then the information has to be provided within 48 hours. Right? Now RTI was amended in the year 2019. Now this act empowered the central government with respect to controlling the information commissioners. Right? For example, when it comes to the terms and conditions of employment, the salaries, allowances of the information commissions, it will be decided by the central government, which means the central government has been made more strong, as now the central government can control who? The information commissions. And this, the central government empowered or amended the RTI Act and made changes to this particular Act of 2023, thereby instructing the PIOs to not share, to not provide personal information to the citizens or applicant, which means right to privacy, right to privacy. This right of the people has been protected under the RTI amendment. So this is the second topic. I hope you understood the second topic as well. Now let us focus on the third topic. Now the third topic talks about how China gradually is controlling the entire African continent. The world knows how China has significantly advanced in the economic and the military sphere. But this article highlights the importance of diplomacy, the Chinese diplomacy in the African continent. Right from economy, right from military, right from, let's say, trade, right from the education, China is foraying into every domain in the African continent. It seems as if Africa is a colony of China. We'll understand. Now, this was a question asked with respect to Indian Africa. However, we'll focus on how China is, playing a major role in Africa. Now, let us try to understand few facts. Africa and China ties began in the year 1950. Now, when many countries in Africa were fighting for independence, China supported the independence movements of many of the African countries, thereby cementing ties with the African countries. Now, in the 1970s, the African continent or many countries in Africa supported China's candidature for the United Nations Security Council seat. Then, the 1999 Go Out policy, which means now this 1990s policy shifted or transitioned China's involvement in Africa, let's say from the ideological involvement to now only economic involvement. Then in the year 2013, because of China's Belt and Road Initiative project, the economic ties between China and the African Union, or rather the African countries, is only growing with time, or rather is only strengthening with time. You see, this China-Africa Cooperation Forum was established in the year 2000. Now, if I talk about the resource access, Africa supplies 90% of global cobalt and platinum, 75% of this for China's tech industry. These resources that the Africa supplies, they are very crucial for China's high-tech sectors, including the electrical vehicles and electronics. Talking of the geopolitical alliance, leverage Africa's influence in the UNGA, the largest voting bloc, to support China's stances, which means when it comes to issues pertaining to China in the United Nations, Africa has always been a great support for China. For example, whenever questions have been raised with respect to South China Sea, where many countries including India claims that China is trying to invade, or let's say control the territories or area of influence of other countries in South China Sea. Or rather, when it comes to Taiwan and Hong Kong, China is violating the sovereignty, or let's say the independence of Hong Kong and Taiwan by sending military threats to these island regions or tiny regions, Hong Kong and Taiwan. So whenever questions have been raised about China's territorial expansion or how China is violating the international rules, Africa has always taken a stand which has been supportive of China's stand. Encourage trade in Chinese currency. So whenever these two regions trade, they trade not in dollar but in Chinese currency, thereby strengthening Chinese currency. Africa, with its young population and emerging markets, is an attractive destination for Chinese exports. So, these are some factual information which you can read by your own. Now, here, if you see institutions like so again, it's very difficult to pronounce this particular school. Now, they train the African leaders, which means even the governance model of China is followed in Africa. The communist ideology of China is taught in the schools of Africa. This is how, using diplomacy, China is trying to influence the thought process of people in Africa. So these are again how China is investing in the infrastructure, how China is providing developmental aid to Africa, culturally how China and Africa are coming together to establish long-term bond or friendship. Now, what are the positive impact? One, there has been infrastructure development in Africa. Why? Because of the Chinese investments. So when it comes to roads, railways, industrial parks, or let's say agriculture advancements, support for the hybrid crops. Again, the technology that Chinese have invented, Chinese are also providing this technology to the African countries so that Africa grows in the agriculture field. Then Chinese non-interventionist approach. Now, the policy that China follows is China never intervenes in the domestic politics, as opposed to the Western countries, where the Western countries have been intervening in the domestic politics. China does not intervene in the domestic politics. China focuses on the overall economic, let's say political cooperation, economic cooperation, cultural cooperation, without intervening in the domestic politics. What are the challenges? Now, some experts say that just like Nepal and Pakistan, the African countries can also be or can also fall in the trap of the so-called Chinese debt trap policy, right? And then it may also empower the authoritarian regimes, which means the democratic principles may dilute. So, so again, the essence of the previous article was about the growing influence of China in Africa, right? Now, the last article. Now, this article is very, very important. What is the title? Supreme Court to take up pleas challenging CEC and EC appointment law in Feb. So, you'll understand about this particular law which was framed in the year 2023. What is the context? The central government had enacted a law. What is the name of the law? This is the name of the law. The Chief Election Commissioner and other election commissioners appointment conditions of service and term of office Act 2023. This law that was made in the year 2023 is challenged in the Supreme Court. Why? Because this law violates the Supreme Court judgment. Now, in brief, I'll try to tell you what is the story. Try to understand this as a story. Before this law was brought into picture, the chief election commissioner and the election commissioners, they were appointed. Who appoints them? The president. The president appoints them. The president appoints the chief election commissioner and two election commissioners upon the recommendations of the selection committee. Selection committee. This selection committee comprises of prime minister, leader of opposition, and third one is chief justice of India. This was a provision before 2023, right? Now the government introduced this law and replaced CGI with Union Cabinet Minister appointed by President. This law says that to appoint CEC and EC, there will be a selection committee comprising Prime Minister, Leader of Opposition, and Union Cabinet Minister appointed by the Prime Minister, which means these two people are of the same political party. So, the CEC and EC will be appointed as per the choice of the Prime Minister and Cabinet Minister. These two people, majority wins. So, these two people are from the same political party. And the president has to simply appoint the election commissioner as selected by the selection committee. But I hope you understood the story. Now, what is the act? I told you what is the act, right? The purpose is to appoint the chief election commissioner and election commissioners. Provision. This act says that to appoint CEC and EC, Prime Minister, Leader of Opposition, and Cabinet Minister. But in the year March 2023, in the Anup Baranwal case, the Supreme Court explicitly held that the inclusion of Chief Justice of India or the inclusion of judiciary in the appointment of CEC and EC is mandatory to ensure the impartiality, independence, integrity and neutrality of Election Commission. Which means in order to retain the independence of election commission, election commission is a body that is responsible for conducting elections in the entire country, the Lok Sabha elections, the state elections, the president, vice president elections. The election commission of India is responsible, which means elections is the foundation of democracy. The essence of democracy is that regular elections are held and the responsibility of conducting fair elections rests on the shoulders of election commission. So, in order to ensure the independence of election commission, the Supreme Court in this case held that the involvement of CGI in the appointment process is very, very important. And what did the government do? In the 2023 Act, the Supreme Court replaced the CGI with the cabinet minister. So if you see earlier we had the prime minister, then leader of opposition in the Lok Sabha and the CGI. But the 2023 Act, what change it make? This is same. Here a union cabinet minister was replaced. Which means by this act the government is trying to impinge upon the independence of the Election Commission of India, which means the government will obviously appoint a person which aligns with the ideology of the government and appoint that person as the chief election commissioner or election commissioners. But this act is going against the Supreme Court judgment as given in March 2023. Now, this particular law has been challenged before the Supreme Court because this law is violating Article 141 of the Indian Constitution. Article 141 of the Indian Constitution says that all the judgments of the Supreme Court are binding on the courts and or they are binding in the entire country. The judgments of the Supreme Court, they are binding in the entire country. So the question is, how can the government enact a law contradicting the Supreme Court judgment given in this particular case? Now the Supreme Court is hearing the case and decision is the decision can be expected at any given point of time. So these are the 4 topics of the day. I hope you understood. The first topic was about UAPA, the provisions of UAPA and the loopholes in the UAPA. The second article was about Right to Information Act. The third article was about the Chinese involvement in the African region and how China is trying to influence or control the African continent. The fourth article was about the 2023 or the act the central government had framed in the year 2023, which impacts the independence of the Election Commission of India. These are the 4 topics that we have covered today. Let us discuss few questions. Now, the first question, the Unlawful Activities Prevention Act has been criticized for its stringent provisions and alleged misuse. Discuss the challenges associated with UAPA and suggest measures to ensure its balanced approach. Very simple question. In the introduction, explain what is UAPA, right? Then in the body of the answer, highlight the challenges in the UAPA, highlight the amendments made to the UAPA, highlight the Supreme Court interpretation with respect to UAPA. Also mention, or rather in the way forward conclusion, you can mention the way forward or the proposed reforms, as in how to reform the UAPA so as to ensure all the challenges or loopholes are removed. This is the first mains answer. Now the second mains answer, analyze Chinese long-term strategy in Africa focusing on economic, diplomatic and political engagements and discuss its implication for global geopolitics. So in the introduction, mention how the ties between China and Africa evolved with time, starting from the 1950s. Then in the body of the answer, mention Chinese involvement or China's steps taken in the economic sphere, in the military sphere, in the diplomatic sphere and different areas, right? And then also mention the challenges like the debt trap diplomacy and finally the conclusion. So the detailed answer can be found in the DNA notes. The link is provided in the comment box. Please open the link and download the PDF wherein you can read the entire content. Now, these are the questions asked from yesterday's DNA. First question is, what is terrain? A fragment of the Earth's crust with distinct geological characteristics, often separated from surrounding regions by faults or structural boundaries. So this is what we understood by the term terrain in yesterday's DNA. A very simple question. That's the reason it is important for you to make sure that you refer to yesterday's or every day's DNA, right? Next, on the planet Earth, most of the fresh water exists as ice caps and glaciers, right? Out of the remaining fresh water, the largest proportion is found in atmosphere as moisture and clouds, is found in freshwater lakes and rivers, exists as groundwater, exists as soil moisture. So again, the correct answer is option C. With reference to sonobuoys, consider the following statements. The sonobuoys are primarily used in anti-submarine warfare to detect and track submarines underwater? Yes. Passive sonobuoys do not emit sound waves, making them harder to detect. Yes. The India-US collaboration on sonobuoys involves joint production as per US Navy standards with facilities in India and the US. So again, very simple questions. All the three statements given here are correct. So the correct answer is option D. And these are the questions from today's DNA. I request you to please open the quiz, the link which is provided in the comment box. Please open the links. Attempt 1, 2, these two questions and please post your score in the comment box. Right? I hope you understood all the articles and any question relating to any topic, I request you to please ask in the comment box. We'll make sure that we address each and every query of yours. On this note, I'll call it a wrap. Thank you so much. Before ensuring that you close down this video, please hit the like, subscribe button. Thank you so much.